Hello. In my upcoming series, I will be highlighting individual legal precedents in Canadian case law that contribute to the framework of unjust, life-destroying prosecutions and wrongful convictions in the area of sexual assault and sex offenses in general that are based solely on reliability and credibility and without affirmative evidence that a crime took place. Before I begin those videos, I felt it would be important to provide some basic root knowledge in layman terms, seeing as I'm not a lawyer or a law student myself, describing how case law and legal precedents work to prime those of you who might not know. Firstly, the R in the case title refers to Regina, which is Latin for queen. So think of any case title that starts with R as the Queen versus the accused, or the state versus the accused, or the government versus the accused. For example, the Queen versus Chuck, which will be my first case I will be highlighting, by the way. Often you will see R versus initials as well, because the case is under a mutual name publication ban, and often also a full case publication ban as well. These cases are criminal court cases. A case title that is a name or initials versus the same indicates a civil court case. These two legal arenas are very different, yet they rely on the same legal precedents. The outcome of a guilty verdict in a criminal court case results in punitive measures such as jail time, whereas the outcome of a civil case results in monetary payouts. In both arenas, however, the accused is forced to engage in the system and to pay for a defense lawyer to defend himself. Secondly, a legal precedent is a new legal principle established by the Supreme Court of Canada, the highest court. When an individual case is appealed to the Supreme Court, they may interpret or reinterpret previous legal principles or criminal code provisions already set out, but were perhaps vague or an issue of contention by an interested party. In my view, when the Supreme Court does this, it doesn't necessarily mean that a new legal precedent is right or fair, just because it's considered to become the rule of law. Any law can be repealed. Any principle or precedent can be overturned. Thirdly, in my view, the premise of a legal precedent is contrary to itself by nature. The irony of a legal precedent is that it is established based on one individual case and its own unique circumstances. However, the precedent then applies to all future cases of similar context as long as it stands in place. Yet the courts are supposed to and claim to decide each case based on its own individual merits and unique circumstances. It seems contradictory to decide the verdict of a unique case based on rules set out in a previous case or a combination of previous cases that were also unique. Having said that, there are some trial judges that will not use or cite case law precedents in their decision process. Some judges will indeed decide a difficult case without any affirmative evidence on its individual and unique merits. Lastly, it is also important to understand that the Canadian Constitution is a living tree doctrine, which means ever-changing. Our common law principles and legal precedents are intertwined with the Constitution. Therefore, it is possible and necessary to overturn unfair and unjust legal precedents. And for the sake of the innocent accused, we need more dedicated and good lawyers to accomplish that. We also need a panel of judges on the Supreme Court of Canada interested in the same. So stay tuned for my first case that must be overturned, R versus Chuck.